Doug asks the following question. Slip and fall on a slippery parking lot surface. Does the contractor who installed the surface have any liability or just the owner of the building? Yeah, the contractor who does and the owner does, both. So Doug, I have a good expert for you. I'll remember his name. Casey will remember his name. I've used him on some stuff, and we've tested slipperiness stuff, because people park and walk on parking lots all the time. You can't have it where that surface is slick, because people are going to slip, especially in the rain. You got to make a surface so that's not slippery. Doug, there's a slipperiness coefficient or something. You can go test that. You can hire an expert to do it. Now you have to make the damages have to warrant the investment of doing the expert. So you all got to remember, so we can go hire experts and stuff, and lawyers do that. We use that so we can put the expert on the stand to testify about stuff, scientific or other things that would help the jury, assist the trier of fact. But it's got to warrant it, because these engineers can be expensive. Doctors can be expensive. So you're not going to hire a $20,000 expert if your damages are only 10 grand. And I know Doug knows that. I'm just kind of explaining that, some of the stuff we think about as lawyers. So I think they have liability, Doug. And I think you got to remember the contractor is going to have a contract with the building owner when they put it in. So there's going to be some indemnity provisions there too. There's also going to, the contractor though also is going to have another pot of insurance or a bond. Sometimes a contractor has a bond or an insurance policy for that specific construction project. That contractor also may have subs who are the ones who decided the paint. You may have an architect who decided the surface type. There's a whole host of things you can get in there. I'd put them on notice. I'd send a lien letter to them, or ask the owner to tell you who it is and send a lien letter. Get the owner of the building to give you the contract with the contractor. It may all be for naught, because if the contractor had an agreement with the owner that after the project was done, the owner had to indemnify the contractor, then you could make the claim, but it still is going to land on the contractor. Excuse me, it's still going to land on the building owner. But the jury doesn't know that. They don't get to see that. Well, unless they do a claim for contractual indemnity, but you could force that, and then you can then the jury can know that the owner owned it, took responsibility for it. The other way to, I think you got to name the contractor, because otherwise you're going to have an empty chair, and you don't want the owner to just sit there and point, hey, there's a contractor, he's not here, and the plaintiff decided not to pursue a claim. So I think you kind of got to do it to avoid the empty chair, to bring in the contractual indemnity issues, to bring in the other insurance bond or the other insurance issues as well. I'd name them, see what you can do.